My name is Zain, and it's a great honour to appear before this court today on behalf of the prosecution. I will speak for 17 minutes, and my lovely co-agent, Wen Wong, will speak for a further 8 minutes, and will reserve 5 minutes for matters.
Yes, thank you very much indeed, Mr. Marns. Jones for the defence.
May it please this honourable court. Good evening, Judge President, judges and esteemed colleagues. My name is Surbhi, and it's an immense honour to stand before this honourable court to present the defence of Mrs. Stella Johnson, along with my co-counsel, Ms. Zain. I will be addressing the honours on the issue of jurisdiction for 12 minutes, whereas my co-counsel will proceed with the issues of individual criminal responsibility and inadmissibility of Ms. Potter's pre-recorded testimony with the OTP for the rest 30 minutes. We reserve up to 5 minutes for such argument.
Thank you very much. Pleasure to see both of you again. Yes, can we start straight away then, please, with the submission by the court?
Madam President, Your Honours, may it please the Court. Your Honours, the case at hand concerns Valerie Porter, a victim of what was an institutionalised policy of wartime slavery. The AIF, having gained control of Asoria, sought to legitimise previous instances of sexual violence through a false veneer of consent, allowing this violence to continue behind closed doors where these women were unseen and unheard. To that respect, I make 2 submissions today. First, that this court has jurisdiction because there are reasonable grounds to believe that Ms. Porter was a victim of sexual slavery under Article 7.1g of the Rome Statute. And second, that there are reasonable grounds to believe that Mrs. Swanson was criminally responsible for that sexual slavery under Article 25.3c. I'll then move to my first submission. Your Honours, the primary contentious matter before you today is subject matter jurisdiction. For subject matter jurisdiction to be fulfilled, there must be reasonable grounds to believe that both the contextual and the specific elements of the crime of sexual slavery have been met. In my submissions, I'll first address the contextual elements, and then drawing on those submissions, establish the specific elements. Your Honours, as to the contextual elements, the relevant conduct must have occurred as part of a widespread or systematic attack against the civilian population. Now, for the purposes of that requirement, Your Honours, Article 7.2a of the Rome Statute defines attack as involving the multiple commissions of Article 7.1 acts, those being the crimes against humanity enumerated in the Rome Statute. We submit that this requirement is fulfilled because the policy of assigning women and girls to each and every AAF soldier constituted a policy of enslavement, which is itself an Article 7.1 Act. Your Honours, enslavement is defined in the Act as the exercise of powers attaching to the rights of ownership over a person. Importantly, the jurisprudence of the trial chamber, for example, in the Wen judgment, at paragraph 2713, as well as in the Taganda judgment, at paragraph 952, have recognised that enslavement may encapsulate situations whereby a victim may not have been physically confined, but where the nature of their situation was such that they felt they had no other options available but to obey the demands of their captors. That is precisely the situation before Your Honours today. The situation of these women and girls was as follows. The AAF entered the town, killed or detained the prior civilian administration, according to paragraph 8 of the facts. And then members of that same force raped or sexually assaulted the women and girls of Asoria, according to paragraph 9 of the facts. And then following this, soldiers of the very same group, often high-ranking leaders, entered the homes of these women and girls and told them, to quote paragraph 11 of the facts, that they were needed to serve a higher cause by living with an AAF soldier. All the while, armed raids were occurring on suspected resistance fighters, according to paragraph 14 of the facts. Your Honours, it's our submission that not only were these women subject to the explicit threat of the loss of government benefits, according to paragraph 11 of the facts, but more importantly, with an implicit threat of violence, that if one did not go with those AAF soldiers, they would be subject to violence. Your Honours, this situation bears similarities to that faced by the court just 3 weeks ago in the Al-Hassan judgment. In that case, women of the town of Timbuktu were assigned to marry and live with members of a violent invading force, with members of that force, the Ansardine, being specifically allowed to select the women with whom they were to live. The assignment was done, much like here today, to integrate the Ansardine into the town, according to paragraph 83 of the judgment. And indeed, much like the case before us today, it was the families of these women that were consulted rather than the women themselves. To quote paragraph 1644 and 1716 of the judgment, the totality of the circumstances was such that these families had no option but to capitulate. In that case, the Ansardine had total control over the town, and as such, in the court's opinion, in that case, the threat of violence was always clear. Your Honours, in that case, the court found beyond reasonable doubt that that situation constituted one of slavery. We submit that the same factors here can give rise, this court, to a finding that there are reasonable grounds to believe this situation was one of enslavement.
You mentioned, of course, the Al-Hassan case, which is the most recent, but are there any appeals chambers authorities which you would wish to cite in favour of your this proposition?
No, Your Honour. The Al-Hassan decision is the primary authority for the prosecution on this point, though of course we have appeal chambers judgments which rely on for the later aspects of my submissions.
Yes, thank you.
Your Honours, to briefly address the remaining contextual elements, it's also clear that this attack was conducted systematically. It involved the assigning of women and girls, to quote paragraph 9 of the facts, each and every AAF soldier, and it's also clear that the AAF is an organisation. Now, Your Honours, before moving to address the specific elements, I'd like to address a particular aspect of the factual matrix that the defence may draw Your Honour's attention to. If I could turn Your Honour's attention to paragraph 13 of the facts. Here it's noted that 3 families successfully resisted the policy of assignment. 2 points on this, Your Honours. First, in the first sentence of that paragraph, it's noted that these were high status families. In paragraph 2713 of the Yongwen judgment, it was noted that 2 relevant indicia of whether a situation is one of slavery is the socio-economic conditions under which power is exercised and the vulnerability of the victims. For that reason, we submit that the successful resistance of these 3 high-status families cannot be taken to indicate that the broader policy was consensual. Moreover, Your Honours, if I could take Your Honours to the final line of that paragraph, it's noted that Mr. Swanson allowed these women to continue to live with their families. Your Honours, allows is not the language of optionality. It indicates that sole discretion ultimately did sit with Mr. Swanson and the AAF, indicating the broader policy was not conducted consensually. Moving then to the broader specific elements. The crime of sexual slavery requires that the victim be in a situation of enslavement and that whilst in that situation, they were made to engage in acts of a sexual nature. Turning to the first element, if Your Honours are with us that this policy was one of enslavement, this specific element largely follows because Ms. Porter was selected as part of this policy. And indeed, the facts indicate that her situation was a quintessential example of that broader policy. She was taken from her family home under what we submit was the very same implicit threat of violence, and according to Exhibit 1, she was escorted by armed guards and terrified as a result. As to the second specific element, the trial chamber in Katanga, a paragraph 978, recognised that this element shall be fulfilled where women are forced to share their existence with a person with whom they have to engage in acts of a sexual nature. That is, from a finding that a situation is one of enslavement, and then from a finding that sexual conduct did indeed occur between the captor and the captee, the same elements that made the situation one of enslavement will have made the victim made to engage in acts of a sexual nature. Here it's uncontested on the facts that Mr. Swanson engaged in sexual acts with Miss Porter, and therefore, if Your Honours are with us that the policy was one of enslavement, this element follows as a matter of course. Do Your Honours have any further questions as to issue 1? In that case, I'll move to the second issue and establish that Mrs. Swanson was criminally responsible as an accessory to the crime of Mr. Swanson under Article 25(3)(c) of the Rome Statute. This requires that the prosecution establish that there are reasonable grounds to believe both the actus reus and the mens rea lim are established. I'll address those in turn. To the actus reus lim, the relevant conduct must have aided, abetted, or otherwise assisted Mr. Swanson in his commission of the crime. Now, as noted in the most recently, though it echoed prior jurisprudence, such as in the Bemba et al. Judgment, the Al-Hassan trial judgment, paragraphs 1221 to 1223, noted that such conduct shall include practical assistance, encouragement, or moral support. And importantly, in those same paragraphs, the justices in the Al-Hassan case, following again the Bemba judgment, paragraph 93, explicitly rejected any substantialness threshold in the actus reus lim of Article 25(3)(c), citing the plain language of the statute and the fact that the drafters of the Rome Statute did not follow the ILC draft code, which explicitly included language of substantiality in the equivalent provision. Now, with that in mind, we submit that Mrs. Swanson played a crucial role, primarily in the form of practical assistance and moral support in the slavery of Miss Porter. To that, Your Honours, we rely primarily on the conduct of Mrs. Swanson in the household upon her arrival in Astoria in June of 2020.
We move on to that. So you're not relying on anything that was said before?
As to the phone calls, Your Honours,
yes,
they established that she had knowledge of the broader policy and that was occurring, and that would be relevant to the mens rea element. But as to the actus reus element, we rely solely on that conduct that occurred in the household.
Yes, thank you.
Now, according to the facts, Mrs. Swanson only arrived once fighting had begun to cease, at which point Mr. Swanson gained, according to paragraph 23 of the facts, substantial mayoral duties. Now, as a result, Mr. Swanson was no longer able to continue the day-to-day running of the household, including the monitoring of Miss Porter's regime of domestic labour. Upon Mrs. Swanson's arrival, she took on this role, acting as a jailer to Miss Porter's enslavement and ensuring that she continued the strict regime of domestic labour to which she was assigned. In this sense, she filled the gap for monitoring for obedience when Mr. Swanson was no longer able to be in the household. And secondly, and relatedly, Your Honours, through her lack of disapproval of Mr. Swanson, her quick uptake of this monitoring role, as well as, if Your Honours are minded to admit Exhibit 1, her cruel and callous treatment of Miss Porter in, for example, requiring her to clean the same spot over and over again, we submit those factors considered cumulatively also amount to moral support to Mr. Swanson in his slavery of Miss Porter. If Your Honours have no further questions as to the actus reus lim, I'll seek to move to the mens rea lim. On the mens rea requirement, Article 25(3)(c) states that the relevant accessorial perpetrator must have acted for the purposes of facilitating the original crime. And the trial chamber in the Bemba et al. Judgment, paragraph 97, states that this requires the accessorial perpetrator lent his or her assistance with the aim of facilitating the offence. Now, Your Honours, the prosecution accepts that there's a paucity of direct evidence as to the subjective mental state of Mrs. Swanson on the facts before you today. But of course, as noted, for example, at paragraph 3 of the General Introduction to the Elements of Crimes, knowledge and intent may be implied from circumstantial evidence. And more importantly, international jurisprudence has stated that where knowledge of another's crimes is combined with further assistance of those crimes, the relevant intent or purpose may be imputed. Authority for that proposition, Your Honours, can be found, for example, in the ICTY Appeals Chamber decision of Krajisnik, at paragraph 697 to 698, as well as the ICTR Appeals Judgment in Karimia and N. Jeremapatsi at 632. And of course, finally, at this stage of the pre-trial chamber, all that need to be demonstrated by the prosecution with respect to the mens rea, following paragraph 1 of the al-Bashir appeal against the decision on the prosecutor's application for an arrest warrant, is that the presence of the relevant mens rea be one of several reasonable conclusions available on the material provided by the prosecution. Now, with that in mind, we submit that that threshold can be made out. Mrs. Swanson was aware of Miss Porter's continued rape by Mr. Swanson, according to paragraph 21 of the facts. And with this knowledge, she acted with continued callousness and strictness towards Miss Porter, continuing the regime of domestic labour which had begun since the day she was taken from her family home. Indeed, through the 9 months she was in the household before Mr. Swanson's death, she never once expressed disapproval of Mr. Swanson's sexual enslavement of Miss Porter, despite their relationship being one evidently via those previous phone calls, being one where Mrs. Swanson could give advice to Mr. Swanson.
Once expressed disapproval, you mean the facts are silent on this?
Yes, Your Honour.
Yeah.
Your Honours, all considered cumulatively, however, we submit there are reasonable grounds to believe that she acted for the purpose of facilitating Miss Porter's enslavement. She had the knowledge of Mr. Swanson's conduct and yet continued to monitor Miss Porter's regime of domestic labour, never once expressed disapproval on the facts. Do Your Honours have any further questions as to issue 1 or 2?
I asked this question this morning, but I think it's worth asking again. What is it your suggestion? You say that she never once expressed disapproval, that she like it. What is it you are suggesting that someone should have done to show disapproval of this conduct?
That would be a matter for any particular case. However, what they ought not have done was to continue the regime of domestic labour that we submit fulfills the actus reus elements. Whatever may have been the acceptable standard of conduct for Mrs. Swanson, it certainly was not what she did on the facts before you today. That concludes my submissions. May it please the Court.
Not as tall as your co-counsel, Miss Wong.
Madam President, Your Honours, may it please the Court. Miss Swanson threatened Miss Porter that if she testified she would lose her son, the only thing that mattered to her. The ICC has recognised that such interference poses a significant threat to the administration of justice. In response, they introduced Rule 68(2)(d) into the Rules of Procedure and Evidence. Rule 68(2)(d) provides a pathway for admitting prior recorded testimonies of witnesses who have been interfered with. The prosecution seeks to admit Ms. Porter's testimony under this provision. To do so, it must satisfy the Court of 6 requirements. though noting time, if it pleases Your Honours, I will submit on the 3 requirements we consider to be at the heart of this case. First, the testimony possesses sufficient indicia of reliability. Second, admission would not unduly prejudice the accused's right to cross-examination. And third, the interests of justice are best served by introducing the testimony. Turning to our first submission, Ms. Porter's testimony possesses sufficient indicia of reliability. The testimony is formally reliable as it was recorded in the ordinary course of investigations and given voluntarily. Regarding the substance of the testimony, the test outlined in Ongwen at paragraphs 19 and 57 is whether the testimony is so manifestly unbelievable or incoherent so as to preclude admission. The defence may point to Ms. Porter's error concerning the consent of her father, who had previously died. However, these facts are analogous to that of witness P61 in Ongwen, whose testimony was admitted. Witness P61 stated that Otti Ligoni was an army leader. However, Ligoni had died years prior. This suggests that Ms. Porter's testimony does not reach the threshold of so manifestly unbelievable or incoherent. Further, as confirmed at paragraph 113 of the ICC's policy on gender-based crimes, it is not unexpected that Ms. Porter made errors concerning the recounting of events as a victim of sexual...
Forgive me for interrupting you. The policy made by the prosecutor, that can't be a reason for judicial action or inaction, can it? So you make your own rules and then you say we should stick to them?
Certainly, Your Honour. We also refer to Article 54(1)(b), where it's stated that the prosecutor in investigating and prosecuting crimes shall take into account the nature of the crime, particularly where it involves sexual violence. And so, although this is a policy of the prosecution to take those considerations into account, that is an appropriate thing to take into account in these circumstances, as Ms. Porter is a victim of sexual violence. Turning then to our second submission, admission would not unduly prejudice Ms. Wanson's right to cross-examination.
Just before you move on to that, on the topic of indicia of reliability, your submission is the fact that she says the whole thing is a little hazy compared to everything that happened after it, is something that we should take into account, but not say that it doesn't show that it's reliable. Because on the face of it, saying it's all a little hazy doesn't exactly inspire confidence.
Certainly, Your Honour. We note that all the prosecution must prove that there is sufficient indicia of reliability. It need not be completely reliable. And further, admitting Ms. Porter's testimony does not predetermine the weight, if any, the court may place on it. For example, as articulated by the trial chamber in Bemba at paragraph 12, fact-finding for cases before the ICC does not fall in the hands of a jury, but rather professional judges experienced in evaluating evidence. And in this light, we submit that Your Honours may take the level of reliability into account when deciding what weight to attribute, if any, to the testimony. Continuing then on the prejudice argument. In line with the approach taken by the trial chamber at paragraph 18 of the Al Hassan P125 decision, Any prejudice resulting from a lack of cross-examination is not undue in this case, as the prejudice is caused by Ms. Swanson's own wrong. Additionally, the Bemba appeals judgment at paragraph 78 confirmed that corroboration is one factor the court may consider in determining whether prejudice is undue. And if I may turn your honours to the third paragraph from the bottom of page 5 of the case. We concede that these statements go to the acts and conduct of the accused. Prima facie, they appear prejudicial. However, that prejudice is diminished by corroboration at paragraphs 21 and 23 of the facts. For example, the claim that Ms. Swanson forced Ms. Porter to do household chores is corroborated by the fact that Ms. Swanson used Ms. Porter for household labour at paragraph 21 and monitored her performance of household chores at paragraph 23. To conclude, turning
Forgive me, I've got another question.
Certainly.
If this statement isn't admitted, your case doesn't hold up, does it?
Your Honour, we submit that that is not the case. The prosecution need only... I note that my time has elapsed.
You can answer the question.
Thank you, Your Honours. The prosecution need only prove that there are reasonable grounds to believe. And the way the prosecution has particularised this case is we've talked about the implicit threat of violence relying minimally on Exhibit 1. And so as though Exhibit 1 paints a picture of the callousness and the psychological control exerted by Ms. Swanson.
Forgive me, I'm going to cut you short because that was a... You say no.
Yes,
You
Your
could
Honour.
carry on with your case even if you haven't got this. But it's an important part of it. Are you prepared to give me that much? It's an important part of your case.
Certainly, Your Honour.
And the only specific evidence about what she... Because you're not relying on her telephone conversations, as I understand what your co-counsel said. You're relying on what she did in the household. Only source of evidence is what Valerie Porter says she did and didn't do. I don't know about my fellow judges. I'm really troubled about the sole and possibly decisive source of evidence being a witness who the defence are never going to get a chance to cross-examine. How do you say we should balance that so that the result is in your favour?
Your Honour, we submit that that can be balanced by the weight that is attributed to the testimony, noting that we are in the pre-trial stage of the hearing, and there are, as I said, there are only reasonable grounds to believe. If this case was to proceed to the trial chamber, we note that conviction is not to be based on a sole and decisive testimony, and that is a factor that the court may weigh into account at that later stage. And so therefore we submit this early pre-trial stage where the decisions of the pre-trial chamber are not binding on the trial chamber, that this testimony ought to be admitted.
Thank you.
May it please the court.
Yes, thank you very much indeed, Ms. Wong. Thank you. Yes, that concludes the prosecution, and we'll turn now to the defence.
The counsel seeks permission to begin. Your Honour, the case at hand today is one that falls wholly outside the mandate of this court to respond to only those most serious crimes of international concern. In the case, Mrs. Swanson, the accused, a national of Allagash state, is facing charges of alleged commission of crimes against humanity of sexual slavery in Margaret. Her involvement is alleged to be through her support and advice given to her husband, Mr. Swanson, on the plan devised by Mr. Dean Walter, the mayor of the town, to prevent rapes and sexual assaults against women. The plan was implemented post the AIF's takeover in Isauria in an effort to bring in stability and governance to northern Margaret. Her subsequent arrest and prosecution are being challenged based on the jurisdictional grounds and the prior recorded testimony of Ms. Potter, which the defense claims is inadmissible. The defense today will present that these allegations against her are unfounded. In this regard, I will make the submission that the case against Mrs. Swanson does not fall within the jurisdiction of the court. Further, I would like to bring the notice of the court to the fact that if the court rules in favor of the defense on any single element of the first two submissions, that is the jurisdiction and the individual criminal responsibility, the prosecution's case must fail and the court should dismiss the allegations against Mrs. Swanson. Now, turning to our first submission, Your Honor, it is our submission that the court does not have jurisdiction in the present case. Your Honor, the defense accepts the prosecution's categorization of the elements required for crimes against humanity of sexual slavery. In responding to the prosecution, it is the submission of the defense that firstly, the ownership element is not met in the present case, since Mrs. Swanson did not exercise right of ownership over any individual. Secondly, that the nexus and the knowledge requirement are not met in the present case. Coming to the first contentious element, the defense submits that the ownership element has not been met. In accordance with the Prosecution versus Korner ICTY decision at paragraph 540 to 542, in order to constitute enslavement or ownership, the perpetrator must have exercised this right intentionally by way of imposing restrictions on individuals' autonomy and loss of movement, or take any measure to deter or prevent any attempt at escape. Further, the Honorable Court in the Katanga judgment pursuant to Article 74 of the statute at paragraph 976 to court has held that notion of servitude relates first and foremost to impossibility of the victims changing his or her condition. The defense would like to draw the attention of the Honorable Court to the fact at paragraph 15 that Ms. Potter, having been provided with the key and the autonomy to leave the house, did not do so, did not flee. Yes, Your Honor. Yes, Your Honor. Despite being provided with the keys and the autonomy to leave the house, did not flee and continued to remain with Mr. Swanson till his death in March 2021. This suggests that Ms. Potter had the ability and the opportunity to leave the house and alter her situation, but voluntarily opted to stay and engage in work. Further, the prosecution today has failed to demonstrate any attempt on part of Mrs. Swanson to prevent the escape of Ms. Potter or the fact that Mrs. Swanson was accessory to any threats of loss of benefits, any intimidation, manipulation, or forms of duress predicated on victim's fear, contrary to what has been argued by my learned colleague. Further, in this regard, the defense would like to bring the attention of the court to facts at paragraph 10 that Mrs. Swanson cautioned her husband to ensure that the relationships that were being formalized were fully consensual. Moving on to the next submission, Your Honor, the defense submits in the alternative that the prosecution has failed to establish reasonable grounds to believe that the nexus and the knowledge elements are met in the present case.
Just a minute, before you leave paragraph 10, what the prosecution is saying, what the facts say, is that Mrs. Swanson was saying, you've got to get the agreement of the family, but nothing whatsoever about the agreement of the girl who was going to be shoved into Mr. Swanson's household.
Yes, Your Honor. However, the prosecution cannot categorize the accused as disregarding the consent of the women, because as seen in paragraph 10, she had not expressly negated the consent of the females that were involved in the relationships. Instead, she emphasized ensuring the consent of the family, which is reasonable when arranging formal unions, as families are significantly affected by such unions. Considering the events and the chaos in Isoria, this particularly, the relationships that were being formalized, it was essential, it was prudent, it was in the view of Mrs. Swanson, it was prudent that the consent of the families should be considered. Further, the defense submits that the very fact that Mrs. Swanson constantly emphasized on consent, firstly when during her initial support of the plan, and which is detailed in paragraph 10, and secondly during when she refuted to offer cash incentives to the families of the women involved, as detailed in paragraph 12, for the fear that it would undermine genuine consent in the relationships.
I'm sorry to further interrupt you, but I really want to take up a point which Madam President, I think, was getting at in her question a moment ago. Are you saying that there's some form of cultural defense here, that because Mrs. Swanson may genuinely have believed that the appropriate person or persons from whom consent should be sought was the families, that we can and should ignore the question of whether the young women themselves were consenting? Is that your submission?
No, Your Honor, it is not the submission that the consent of the female should be completely sidelined due to some cultural considerations. However, it is the submission of the defense that the very fact that Mrs. Swanson did not completely obliterate the very essential aspect of consent in these relationships should be considered to determine that Mrs. Swanson did not want to further any act of sexual slavery by the way of unions. Your Honor, coming on to the next contentious element, in the alternative, it is a submission of the defense that the prosecution has failed to establish nexus and the knowledge element in the present case. Per the Ongwen trial judgment at paragraph 2690, and to quote the judgment, the nexus requirement finds its subjective equivalent in the knowledge of the attack. That is, in order to fulfill the nexus element, it is crucial that the perpetrator must be fully aware that the actions are directly contributing to the attack. In the same judgment, the court had held that knowledge requires virtual certainty that the consequence will occur. Further, the court in its findings on the knowledge element in the Ongwen judgment noted at paragraph 2805 that Ongwen knew the LRA killed, injured many civilians, and abducted, enslaved, and used people as sexual slaves. However, in stark contrast to this, Mrs. Swanson does not meet the required threshold of knowledge in the present case. From paragraph 21 of the facts, it is clear that Mrs. Swanson arrived in Isauria only in June 2020. Prior to that, her information of the plan and the events in Isauria was based entirely on what limited information was given to her by her husband, Mr. Swanson, who constantly claimed, as evident in paragraph 10, that the plan was implemented to prevent the havoc that was being caused by the AIF members. Consequently, Mrs. Swanson was committed to ensuring the consent in such relationships, which is clear from her initial support of the plan, which was contingent on securing families' agreements, and her refusal to offer the cash incentives in the, as detailed in paragraph 12, for the fear that it would vitiate the very essential aspect of consent in these unions. Your Honor, in line with the requirement of virtual certainty, it is the submission of the defense, the very fact that Mrs. Swanson constantly was emphasizing on consent, it cannot be reasonably inferred that she was virtually certain that sexual acts of non-consensual relationships would occur in such unions. Your Honor, coming on to the argument of the prosecution regarding the existence of a systematic attack, the defense would like to bring to the notice of the court the purpose of the requirement of systematic attack is to exclude a random act which was not committed as part of a broader plan or policy. In the context of the plan, which aimed to formalize relationships between women and AIF members to prevent sexual crimes against women, alleged instances of non-consensual sexual acts committed by certain rogue actors surpassing and acting in violation of the plan does not constitute a systematic attack or organized nature of violence. Your Honor, if the counsel cannot assist you further, the counsel would like to yield the floor to my co-counsel for their submissions. Thank you, Your Honor. It was a pleasure pleading before the bench.
Thank you very much. Ms. Khan, do you want to chair?
I'm good, thank you.
Right.
Madam President, Your Honours, may it please the court. I am Zain Khan, and today I am appearing as the second counsel for Ms. Stella Swanson's defense. And in the remaining time, I shall be addressing the second issue related to the individual criminal responsibility and the third issue related to the admissibility of the interview transcript. It is the defense's case that the prosecution has failed in its duty to establish reasonable grounds to hold our client, Mrs. Swanson, responsible under Article 25(3)(c). And since they have focused primarily on the acts that happened inside the house, while the counsel will consider other acts, she will also focus on these acts in question. Firstly, moving on to the material elements required. There are three prongs which are to be considered to establish liability. Firstly, the material elements, that is, the actus reus needs to be established. Secondly, it is the defense's case that the substantial effect threshold also has to be met. And thirdly, that the mental elements that are required under this particular form of liability also has to be met. It is the first submission of the defense that the prosecution has failed to prove that a client provided assistance because according to modern theories of attribution, such as that applied in the Bemba judgment, as well as that applied in the Nataganda judgment, assistance requires either the creation or increase of risk of the commission of the offense. Considering, in the present case, that Miss Valerie Porter was already inside the house when Miss Swanson, is there any question? No. When Miss Swanson came in 4 months after the affair had started to find her already living in the house, the defense contends that we see that neither there was a creation of the risk of sexual slavery, nor there was an increase of the risk of sexual slavery that was already taking place. Secondly, it is the defense's contention that the prosecution has failed to prove that the substantial effect, that there is a substantial effect caused by the actions of Mrs. Stella Swanson. Firstly, the defense puts forward the ICTY judgment of prosecution versus Tardick, where it was held that the threshold is only met if the crime would not have occurred in the same way without the alleged assistance. And in the past, contextual factors such as the position of authority that the person was holding and that the influence they wielded were considered by the court to come to a determination. In the present case, the contentious plan that we're talking about, was conceived and implemented by the Mayor Dean, way before our client, the accused, even got to know of it. Secondly, from the very beginning, it has been the client's stance that whatever actions the AIF undertakes, they should ensure that they are fully consensual in nature. Moreover, highlighting the fact that she was neither a member of the AIF nor wielded any influence outside of the AIF, we submit that the influence that she wielded was too remote to cause such a substantial effect on the commission of these crimes. Moreover, the prosecution may argue that she had advised her husband on certain considerations, but if you're honest, refer to paragraph 11, and we look at the account that witness P013 provided.
Forgive me for interrupting you, but I'm not sure you have to go there. As I understand it, the prosecution are not relying on the telephone conversations. That's right, isn't it? So you're tilting at a straw man here. You can move on to your next point.
All right. If the bench is satisfied, I will move on to more specifically about what happened inside the house. Yeah. Moving on to the next requirement, that which more specifically deals with the relationship that was unfolding between the three parties inside the house. We contend that the required mens rea element, the required mental element, is not met in the particular case. Firstly, the prosecution had to prove that under Article 30, the accused was aware of the fact that sexual slavery was happening in the first place. And secondly, they also have to prove the higher threshold of Article 25(3)(c) of showing that the accused had the purpose of facilitating the commission of sexual slavery. And it is the defense's case that neither were present in this factual matrix, as we see that the accused only learned of the affair after arriving in Astoria in the month of June 2020. This was nearly 3 to 4 months after the affair had already began in February 2020. Moreover, if we consider the fact that in paragraph 16, it has been highlighted that Mr. Swanson had repeatedly assured that the relationship between him and Ms. Porter was fully consensual, and this coupled with the fact that Valerie Porter possessed a key to the house, and it was clear that long after even Mrs. Swanson had arrived in Astoria, she continued to live there and then had even a child with her husband. This provided no basis for the accused, Stella Swanson, to then suspect that the relationship was anything but consensual. Moreover, the defense would also like to highlight that Valerie's non-consent to her relationship with Mr. Swanson is presently entirely hinged on the admissibility of the interview transcript, as nowhere else has it been corroborated, apart from the interview transcript, that the relationship between her and Mr. Peter Swanson was not consensual in nature. Yeah.
All right, just pause for a minute before you move on to the evidence. When Mrs. Swanson arrives, she finds that there is this woman in her husband's house sharing her husband's bed. She then moves the woman to the next door bedroom so that her husband can have continued access. She monitors the work done by the woman who's there. Isn't that aiding and abetting the offence if the other elements are made out?
Your Honor, it is the defense's case that if we look very particularly at Valerie Porter and the conduct that was taking place in the house, we see that this isn't aiding and abetting because, as highlighted earlier, the requirement is that there is a creation or an increase of the risk of sexual slavery to have firstly taken place. And secondly, we see that the prosecution has characterized it quite unreasonably because, as noted by Your Honor, a woman has now come to visit and live with her husband in a foreign town, a man who is in a lot of power. And now she sees out of nowhere that he is having an affair with another woman. It is then very much reasonable for her to take care of the domestic politics and then to ensure that she still has a place in a foreign state where there is no other support system for her. Therefore, it is very much reasonable for her to have acted in this way and have moved another woman out of her husband's bed, out of her marital home. Yeah. Yeah.
Thank you.
Madam President, if I may, Counsel, aren't you underestimating the concept of slavery, which by nature brings with it a hierarchical concept, right? Mm-hmm. And your colleague touched upon the right of ownership. Mm-hmm. And you also raised the fact that Miss Porter had a key. She could have left the house whenever she wanted. Mm-hmm. But if you see the whole situation in the house, and being in a country with a policy of enslavement, how realistic is the proposition that she would have been free to go?
It is the defense's case that when we're talking about Stella Swanson in particular, and when we're talking about Miss Valerie Porter in particular, we see, as would have been argued by the counsel in a broader picture, Stella Swanson never intended for sexual slavery to take place. Stella Swanson wasn't present in Essoria to see what was happening on the ground. All information that she had was on the basis of what her husband had been telling her. And with respect to the domestic chores that she was then overseeing, we see that a lot of it then just hinges on whether Valerie Porter was in a consensual relationship with Mr. Swanson or not, and that is the defense would again like to highlight. The only way that could be considered by the court is if the interview transcript would be admitted, and it is the defense's case that the same should not be admitted if the defense, if the counsel is allowed to proceed with that argument. And she will then tie it together for Your Honor later. Yeah, okay.
Madam Counsel, I have one small question to you. What can you say to us about Mrs. Porter's son?
Miss Porter's
Son, yeah.
Yeah.
The baby boy. Mm-hmm. Can you say something about him?
The baby boy, then again, is a proof of her continued relationship with Mr. Swanson, even after the armed disturbance in that area had decreased to a much large extent. And even when, as shown by the possession of a key, she had a choice to go. And nowhere in the facts is it shown that there was some specific negative action taken against the victims who had tried to flee. So we say that this is proof that it was a consensual relationship. Yeah. Moving on to the third issue, I seek to highlight that it is the court's duty to uphold the principle of orality as given in Article 69(2) and the principle of equality of arms as given under Article 67(1)(e). And by permitting deviation from the procedural guidelines as given in the Rome Statute, the pretrial chamber has to be very careful of the precedent that it then sets. It is not the defense's case that Valerie Porter be excluded fully as a witness. We only contend that her interview transcript not be admitted as a prior recorded testimony, as this would be a breach of the court's duty. Firstly, because the pretrial chamber lacks authority to determine the admissibility of the same under Rule 68. And secondly, the prosecution has failed to satisfy the requirements of Rule 68, therefore, they cannot be allowed to take recourse of the same. And lastly, the admissibility of the testimony would be perverse to the interest of justice. It is the defense's case, if I could just get 1 more minute to you. It is the defense's case that under Rule 68, which is a special power and exception, the power is specifically given to the trial chamber to consider such an admissibility. Yeah, sorry. Sorry. Yeah.
Yeah, start again, because the mobile phone was distracting.
Yeah.
Can I remind the spectators that mobile phones or counsel should be switched off?
Under Rule 68, the rule the prosecution has decided to go under, the power is specifically with the trial chamber, and it cannot be expanded or interpreted in an expansive way, because as according to the Al-Hassan judgment in para 83, since this rule is subordinate to both Article 69 and 67, it is the court's duty to strictly interpret it to protect the procedural rights of the accused. Our second submission is that the prosecution had available recourses that it could have taken, and it failed to exhaust all of them, as was required in the Gicheru trial judgment in paragraph 20 and 21. It failed to approach the pretrial chamber under Article 56. It failed to approach the pretrial chamber to get a summons issued to ensure that the witness comes and stands in attendance. And secondly, it failed to check the veracity of the email that they have claimed was sent by our client, because if we consider paragraph 3, Stella Swanson was already in the court's custody when the email was allegedly sent, and the same was also known to the office of the prosecutor. And it has also failed to show how a single email by a disgruntled woman meets such a level as to cause a material or substantial interference. And lastly, that the transcript lacks internal coherence and it only relates to the conduct and acts of our client. And since the defense till now has not had a chance to cross-examine, in the interest of justice, it is the fundamental right of my client of a fair hearing, and in holding so, the court should not admit this present interview transcript.
You've run out of time, but I think I, on behalf of maybe myself and my colleagues, I just need an answer. I'm sorry, are you suggesting that there's no proper evidence that Mrs. Swanson sent this email?
The prosecution has failed to show that it undertook enough investigation to come to this conclusion, because as seen in paragraph 3, Stella Swanson was already transferred to the court custody, and this is before the email had been sent.
I'm sorry, I didn't quite follow that. Paragraph 18 says that the OTP produced the email. Are you disputing the authenticity of that email?
We are disputing the authenticity.
You are. I see. That's all right. That's all we wanted to know. Thank you very much.
Thank you.
Yes. Yes, well,
it
thank
has
you
been
very
an
much.
honor. May it please the court.
Thank you, Ms. Khan. Yes, rebuttal.
Thank you, Your Honours. May it please the court. 2 points in rebuttal, one going to issue 1 and one going to issue 2. Our learned friends relied substantially on the fact that Ms. Porter held a key to indicate that the situation was conducted consensually. Here I'd refer to my earlier submissions on the fact that there was an implied threat of violence in the conductum of this policy. The entire town was controlled by the Alleghenian Independence Forces, a force that was previously violent to the women and girls of Astoria. In this sense, the threat of violence, if she did attempt to escape, would have always been clear to Ms. Porter. Indeed, a similar consideration was made at paragraph 1433 of the Al-Hassan decision, wherein it was noted that the fact that the Ansar Dine controlled the entire town of Timbuktu furthered the situation of slavery. Second, as to issue 2, our learned friends noted that Ms. Porter was already in the house when Mrs. Swanson arrived, and in that sense, her presence did not, to quote, increase the risk of sexual slavery occurring. Firstly, we reject the characterization of the actus reus test as increasing the risk. In the Al-Hassan decision and the Bemba et al. Decision, paragraph 93, the courts explicitly rejected any sort of substantialness threshold. And nonetheless, this is why, Your Honours, we framed our submissions at first instance in light of the change in circumstances as noted at paragraph 23. Mrs. Swanson arrived once Mr. Swanson had to take on further mayoral duties. And in that sense, there's been a relevant change in circumstances such that Mrs. Swanson's arrival has in fact furthered the commission of sexual slavery. Your Honours, to conclude, Mr. Swanson held Miss Porter in enslavement and made her engage in acts of a sexual nature with him. Mrs. Swanson aided and abetted that slavery through her continuation of the regime of domestic labour. May it please the court.
Thank you very much indeed.
Sorry, I thought there may be maybe other questions. Mr. Hans, what do you say to the defense's proposition that the mere fact that Miss Swanson joined the household of her husband with this situation of enslavement already in place, she had no possibility, well, certainly to reverse the situation, but at the end of the day also no possibility, to change her husband's attitude. Is that a necessity at all for coming to the conclusion that she was aiding and abetting the crimes allegedly committed by her husband. And maybe if you have some authorities, actually more factual authorities from other cases that you could speak about.
Thank you, Your Honour. As for factual authorities, on the prosecution's awareness, there's no similar circumstances involving the commission finding a wife liable in such circumstances in international criminal jurisprudence. But of course, there has been a number of cases in German domestic courts, in the Dusseldorf higher courts, in relation to the Yazidi cases, in which case wives were held criminally responsible. And in that sense, this case is similar to those. With respect to the... My apologies, Your Honour. Could you repeat the first aspect of your question?
Well, I think your answer was already very much to the point. Thank you.
Thank you. May I please the court?
Yes, defence.
Your Honours, Madam President, the defence seeks to raise two main points of rebuttal. The first one being related to the quality of the relationship that is being put forward by the prosecution. For the same, the defence puts forward the authority of the Sese case, which was adjudicated in the SL court. And in paragraph 953 of that judgment, it was held that the duration of the alleged enslavement, although not an element of the crime, it may still be relevant in determining the quality of the relationship. Related to this, I would like to draw the attention of the bench to paragraph 14, the very last line. The very last line, if Your Honours allow me to read out, state that the entire process lasted from 3rd February through 6 May 2020. And this is with specific reference to, as we see in the sentences above, related to the occupation of the town and the fighting that was happening in the streets of Isauria. It is then the defense contention that considering that the fighting and the hostility had ceased sometime around May 2020, and noting the fact that that Valerie Porter still stayed in the Swanson residence, had a child, and was there till sometime around March 2021, this shows and does raise a lot of questions about the narration that is being pushed by the prosecution, and once again acts in our favor as to showing that there is a very good chance of a consensual relationship between Valerie Porter and Mr. Swanson. As to our second point, we would like to hold that the prosecution cannot be allowed to hold Valerie Porter responsible for omitting to act or for not expressing displeasure as to the acts that were carried out by her husband, Peter Swanson, because as held in the ICTY judgment of prosecutor versus Bradnan, in the appeal judgment, it was held that in order to hold someone liable for omitting to act, there has to be a legal duty to act in the first place. And in the absence of this legal duty, the prosecution then cannot be allowed to peddle their argument of Mrs. Swanson then being a silent spectator. With that, I rest the defense's case. Yeah.
Are there circumstances where failing to take certain steps actually can only lead one to draw the conclusion that they were assisting in the actual commission of the offence? Or do you say if a failure to act in all circumstances can only be used if there's a legal duty to act?
In the past, where the court has ruled on liability caused by omitting to act, It has only been in the context of there being a legal duty to act in the first place. For example, in the Bemba trial judgment, while dealing with the liability of, I'm sorry, I might mispronounce it, Mangenda, it was held. He was held to be responsible for his tacit approval because of not saying anything when the tutoring of the witnesses was going on. He had a legal duty to act, being a part of the defense team in the first place, and that is something that the court did rely on in their consideration. Yeah.
All right.
Okay, thank you.
Yes, thank you.
Can I
yes.
just follow up on this? Would you, if the prosecution said that the mere situation of slavery in a closed household, and I'm not even talking about sexual slavery, but just slavery, and you came in as a free person, would you say that you had a duty to act?
A moral duty, maybe, but a legal duty, maybe not. And I feel that that is the key differentiation for a prosecution by the ICC and maybe some other court. Yeah.
Thank you for answering.
Thank you.
Yes. Well, thank you all very much. The bench will retire to consider the submissions which have been made. My normal habit when presiding has been to give the decision first and then give the feedback. However, as this is the final, we thought if we give the decision straight away, nobody's going to listen to the feedback. So we're going to delay slightly, only slightly, the feedback that my colleagues, and I will round up at the end, are going to give you, on the basis that this is the practice for real life, as I've said to you, and so I think it may help, even at this late stage, if we give you a little bit of feedback. So, we'll start from my left, Judge von Wistinghausen.
Well, first of all, bravo. Fantastic performance, really. I've never done any moot courts. I would die even today after like 20 years of experience in courtrooms to stand here and to do what you've done today. So really high quality submissions on both sides. Fantastic work, good, you play with the facts and the law. Of course, you had a long time to prepare, which is not always the case in the courtroom where sometimes, things come up very spontaneously. But again, I have a huge admiration for your performance, so congratulations for that. Maybe just a few words regarding feedback. What I really appreciated is that you gave good introductions of what you were going to talk about. There was a good eye contact. You were in contact with all of us, which is really important, and mimics. You will see the mimics of the judges, and it will also tell you something. Are they listening? Are they agreeing, disagreeing? Do you have to go, further into the details or dive more into the into the submission? So that was really good. Obviously, well, you know the facts, you know the law. Sometimes the questions that we ask are maybe a bit unexpected, and that's maybe also a bit frightening. Okay, so what's coming now, and do I get the gist of the question, and do I have the answer on the tip of my fingers? If I don't, that's just day-to-day experience in the courtroom. It's completely normal. We still have it all the time. So even if the answers are not always perfect, don't worry. And sometimes we ask questions we don't have the answer to. Actually, this is why we ask the question. As we say, like two lawyers, sometimes at least three opinions, depending on what side you're on. Probably the skill is just to, again, not to shy away from being creative, but by staying realistic. With the word realistic, I hand over to Ben, because he wants to talk about that. Thank you very much. This was very enjoyable. And again, bravo.
Yes, I do want to mention the word I keep doing that, disappearing below the bench. When you, as I suspect many, if not all of you will, do advocacy for real, with real clients. I think it's important to remember that whether your tribunal be a bench of judges or a jury, right from the moment when you first appear, before you've said a word, I think it is useful to think of yourself as like a person with their bank account. You are establishing credit or debit with the judges with every movement that you make, every gesture, and of course every submission or question you ask in another context. And it's vital, obviously, for your client that you keep your credit balance high. One of the ways in which you can do that is by making realistic concessions, by paring the case down so that instead of the judges having to hunt up the truffles of what the case is about, you've boiled it down for them so that there are only 2, 3, 4 decisions they have to make. There is nothing that a judge likes better than parties who can simplify the real issues. You lose nothing by making realistic concessions. You can gain an enormous amount of credit with the judges. I mean, ultimately the judges will make decisions which are just, as opposed to decisions in favor of the party they think has been nicest to them in the course of the proceedings. But the subliminal effect, the advocacy effect, and that's what this is all about. I mean, defense, I've seen you chaps defend this case as well, or some of you. I mean, it's an uphill struggle for the defense, this case. That's the reality of it. But, you know, the essence of what we're judging here is not, is the prosecution case stronger or is the defense case stronger? It's how you've argued it. And so I come back to the word realistic, which Judge von Wistinghausen mentioned a moment ago. Realistic concessions, that is hard to do, particularly when you're kicking off, when you're starting. It feels as though you're giving away some of the crown jewels, your treasure. But in fact, it is something which is highly persuasive for judges.
Thank you, Judge President. I don't know if I can say better than my 2 predecessors, but what I would like to say, just to resume an idea, we usually have in French speaking. You know what is being conceived very well. You can say it clearly, and the word for saying it can come easily. En français, on dit ce qui se conçoit bien se dit clairement, et les mots pour le dire viennent aisément. Et donc, I think that is just this kind of exercise we have followed just now, coming from the 2 teams. And personally, I don't want to give more advice, because it has been coming by all of you here. I will not find the best word to say it, but I can say that I'm happy. I'm happy for what I have seen. I have a chance to meet one of the team, and I got better chance to win the second team also. And I can say that we as judges, we have done our best, and they have done their best too. I just want to continue to congratulate them, and to say that maybe the best will come for you if you continue to improve yourself on the way on which your judges are advising you, are speaking with you, and also to continue to be humble, but very rigorous on, because the law is very rigorous. You have to be rigorous but continue to be humble in your way. That is what I can say, Judge.
Thank you very much.
Thank you. I can only echo the sentiments. You have my congratulations. You have my thank you. It's always such a pleasure to watch teams start off in the beginning of this blur of summer days and really go through the steps of improving and piecing together the case a little bit better with each round until we get to this room and we have the pleasure of sitting here and seeing really fantastic arguments put forward where you can make some concessions, but the one thing you didn't give up was control. At no time did it feel like you'd ceded to the bench or you'd lost any of it. You managed to take the questions and come back with answers. You managed to stay back on track and in time and keep control of everything, at the same time, the facts and the law, and really by this stage now also seeing them married together. How do they fit? And so it was really a great pleasure from my side to have the seat right here in the front row and watch this today. So thank you very much for your interventions and all of the best for this evening and the future.
Right, well, all I'm going to say is that I've seen both teams. In fact, the defence team this morning, earlier this afternoon, and the prosecution team earlier this week. And I'm absolutely delighted to say that I gave advice and both of them in one way or another took it. So I am not going to repeat the advice. I will have, I'm told I have to say something a little later at the awards ceremony, so I will say a few general remarks. Just one thing, and I've noticed it with all the teams, and that's this. All of you have been saying one form or another, you know, unless your honours have any further questions, we'll move on. I know it's because you think it's being polite, but actually, after a while, it just becomes irritating. And basically, you will get crusty judges saying, Mr. Marns or Ms. Khan, if I have any questions, I'll ask them myself. So you don't need to do it. As you've seen, and as I've explained already, we ask questions because we really want to know. And the worst kind of judge from our, I think, experience is the judge who says nothing and you have no idea how your arguments are being received. And so there is a real reason why we ask those questions. As I say, if we want to ask questions, as you've seen, we'll ask them. So having said all that, I'll say a little bit more generally about this competition and about mooting and its value a little later. But finally, what the two of you have been waiting for, I've said it in all cases, it's a shame in many ways, particularly when you've both worked so hard and succeeded in reaching the final, that you can't have a draw, but you can't. On this occasion, we find in favour of the prosecution team. And however, as I say, we do congratulate both teams, and as I say, it's just bad luck. Somebody has to lose. But thank you all very much, and the bench will adjourn.